Your Honour, the next organisation is the Alliance for Forgotten Australians. Oh, I'm sorry, I'm told my list. What's on my list? Sorry? Oh, I'm told there's been an amendment to my list, and perhaps if we could have the Insurance Council of Australia first.
I'm sure Ms Carroll won't mind.
Mr Whelan, you're the Chief Executive Officer of the Insurance Council of Australia.
That's correct.
I invite you to speak to your submission.
Thank you. I'd like to read a brief opening statement before going to questions. Your Honours and Commissioners, thank you for the opportunity to appear here today at this public hearing to speak to the submission of the Insurance Council of Australia. The Insurance Council of Australia is the representative body of the general insurance industry in Australia. We represent insurers that underwrite liability insurance. We also represent reinsurers. Some of the Insurance Council's member companies offer liability insurance to institutions that may cover the risk of child sexual abuse. In preparing the Insurance Council's submission in response to the consultation paper of February 2015, the ICA Secretariat consulted with members of our Civil Liability Committee. The ICA acknowledges the terrible and long-lasting effects of child sexual abuse and the suffering of survivors. We acknowledge the need for meaningful reforms, the benefits of the establishment of a redress scheme, and the fact that the needs of survivors will be best supported via cooperation between a multitude of public and private sector organisations. The submission of the Insurance Council explains the role of liability insurance for institutions and the potential impact that proposed reforms may have on the availability and affordability of this line of insurance. As with other lines of insurance, our message is the same. The best protection against risk is strong and consistent management and mitigation. Strong risk management and mitigation can support the affordability of general insurance. And when tragic events do occur that cause damage, insurance assists individuals and organisations and communities to recover. The Insurance Council and the general insurance industry support any reforms that will, as far as is possible, reduce the risk of child sexual abuse. And we accept that this is not an easy task. However, as noted, there is a direct correlation between affordable and available insurance and strong risk management. Much public awareness and knowledge has been gained through the historical extent and circumstances of sexual abuse of children in institutions. Due to the work of the Royal Commission and the courage of individuals and organisations to share their stories, it is a reasonable expectation that all organisations responsible for the care of children will utilise this knowledge and take all responsible steps to ensure that such abuse does not occur again in the future. While liability insurance for institutions cannot realistically be a perfect solution for damage caused by child sexual abuse, it can provide a source of compensation for a survivor who makes a successful claim against an institution. Institutions, families and communities also benefit when a source of compensation is available for a survivor of such abuse. We therefore strongly caution against any reforms that may adversely impact the cost of liability insurance for the risk of institutional child sexual abuse. The consultation paper considers expansion of civil liability settings, that is, the removal or extension of statutory limitation periods and a more onerous duties for institutions that are responsible for the care of children. If governments expand civil liability settings retrospectively, this could adversely impact insurers' capital positions. If governments expand civil liability settings prospectively, this will adversely affect the affordability and availability of liability cover for child sexual abuse. As we have outlined, due to the nature of risk, this insurance is typically the only available option cover at a higher premium. Sorry, I'll read that again. This insurance is typically only available as an optional cover at higher premium. Rather than adjusting the nature of the duty of institutions by statutory amendment, the responsibility of institutions to protect children in their care should be supported by mandatory risk management requirements so that the risk of child sexual abuse is reduced. Thank you, Your Honours and Commissioners. I'm very happy to take questions.
Mr. Whelan, I'm going to travel ground that we've travelled before. But everyone should, I think, understand
Brisbane, Australia,
your
Senator
perspective
Stevens.
of the issue. The common law and the rules that establish liability, be they common law or statute, has been used for all time as a means of imposing discipline upon the behaviour of individuals and institutions in the community. I think that's accepted, isn't it? Mm-hmm. The underwriting then of insurance to insure the individual or the institution is a way of endeavouring to provide financial stability in the community when there's a transgression of the duty that the institution or individual owes.
Yes.
Correct?
Yes.
And for the insurance industry, that really becomes a question of the dollars. What do you want? And you say, then how much will it cost?
Yes.
And although if you change the rules, obviously, there may be a change in the premium structure, it's a community question as to whether or not that's a good thing, having regard to the change which you may get in institutional or individual behaviour.
Yes.
Now, looking forward, as I think you point out, it's just a question of what is the cost of providing the insurance which the institutions may need in the context in which we're talking.
Yes.
And I don't think there's any suggestion that the insurance industry would entirely walk away from the sector, is there?
Yes, that's right.
And can you tell me then, in light of that, do you know of the experience in England since the Supreme Court changed some of the rules?
Regrettably, no, Judge. We have begun some inquiries there, but it may be early days in terms of the implications for insurance. This will take some time to flow through to actual cases and so on. So I don't have anything specific, but would be happy to seek any further information that would assist you.
Well, it might be useful if you perhaps would be able to gather evidence of where insurers have been alerted to a claim that might be about to emerge in the courts, mm-hmm. which, if that could be gathered, would be of real assistance to us. Yeah. But we appreciate that subsequent decisions may take more time.
Yes, certainly.
To come through. Now, the second issue is the statute of limitations. You know that the Victorian government has moved to remove that limitation, and that will have a retrospective effect. If Victoria go down that path, what consequences does that have for the insurance industry, which of course seeks to provide insurance across Australia?
Well, it will have variable effect on different insurers depending on their exposure. As you know, not all policies necessarily covered child molestation or sexual molestation as part of their standard policy, and if they did, in many cases they were as adjuncts to the standard policy. So it will vary by individual insurers, but we would all take note of those decisions by the Victorian courts, and we'll need to adjust our thinking going forward. But the concern of the industry generally is not so much about prospective changes. The industry can adjust to most of those sorts of things over time with a better assessment and recalibration of risk, and therefore able to assess what the appropriate risk premium should be and how best to manage that risk premium and those claims as they go forward. It's the retrospective situation where the assumptions that policies were built on and premiums were struck and capital was allocated and so on are what drives, I guess, how the insurers manage their business. And if they are changed on the insurer, such as the statute of limitations or the duty of care and so on, that has a demonstrable effect on their position, because they have to rethink about their position in terms of their capital and their provisioning for those sorts of claims, because they weren't taken into account in the original premiums. And therefore, adequate premiums were not collected to take care of that risk. So it's the imposition, I think, of retrospective changes that concern the industry the most. Prospective, I think, we're able to engage and discuss about how that will affect the insurance industry going forward. It's the retrospectivity that concerns us.
And if Victoria do move in the way that they have done, how would the industry respond in terms of restructuring the liabilities of insurers? Would it be a question of raising more premiums going forward to pick up what you haven't funded in the past? Is that how it operates?
Essentially, it will flow not only to the direct insurer but also to the reinsurers as well, and how they calculate their costs to the insurer. So ultimately, there has to be a adjustment going forward to compensate for claims that weren't adequately funded. So over time, you might expect some premium increases to adjust to that, depending on what the claims come out like.
And would that be spread across all forms of insurance, that premium increase, or would it be confined to the insurance that meets the particular liability created by the removal of the statute of limitations?
It would really be a decision by individual insurers, because that's a commercial decision, but most typically it's done within the class of business.
Within the class of business, so that institutions caring for children might carry a greater burden going forward.
Yes, they represent a considerably greater risk profile than institutions that don't have a care of children under their responsibilities.
I'm sure you accept that some people may see that as an appropriate social outcome. That is, that through the insurance industry, the institutions should carry that burden going forward.
Yes. The only caveat I'd add to that is that there's a concern about the cost and affordability of insurance going forward and the accessibility of that insurance. Any concern I'd have would be about whether those costs start to make certain institutions unable to take out that sort of insurance. The costs associated with those specific requirements around child abuse or sexual molestation within the policy. And I guess that accessibility for some institutions to be able to take that cover out. And also whether the insurance companies going forward will continue to have an appetite to underwrite that risk.
Well, they're questions which we presently can't answer, aren't they?
Yes, that's right. And they are concerns, because the flow-on effects are undetermined.
But we cannot determine them before they happened.
No.
No. So someone has to make a decision that reflects a social outcome, and then we'll have to review, I suppose, or the industry would have to review as it goes forward.
That's right.
Yes.
I have no questions, Your Honour.
I've just one. The Insurance Council has now come out to support the establishment of a redress scheme. Although I note in the submission, the Insurance Council has now come out to support the establishment of a redress scheme. And I just want to understand what would be any of the, or one of the most significant caveats that you put around the support of a redress scheme.
Yeah, we thought long and hard about this. It's really how any redress scheme as designed, and we're yet to see the full detail of how that might look, but how that interacts with current law and current liability settings, and what does that mean in terms of our responsibilities to the institutions or the insurer that we have current policies with. So it's how those two elements interact is, I guess, the concern that we'd like to see more detail about how the Royal Commission recommends that be developed.
So if I can just ask this specific question, for example, at the moment, does the Insurance Council of Australia have a position in relation to the eligibility for the establishment of a claim pursuant to a redress scheme, or are these matters that you see as being part of the ongoing consultation?
I do see them as part of the ongoing consultation. Again, who is involved in the scheme and the terms under which they're involved in the scheme, and their ability to bring a live claim against an institution, which an insurer may or may not have to respond to depending on the terms of its policy. is something that we need to understand pretty fundamentally.
Thank you.
I have a question to you, please, Mr. Whelan. I thought your remarks about the dangers of retrospectivity well expressed, but I want a little better understanding of the reality of those dangers. And if we look at Victoria, it would seem to me that historical cases of abuse, where they can be allocated to a specific perpetrator over perhaps hundreds of victims, and you'd be aware there are those cases, and there was knowledge within the church, for instance, that had occurred, the insurer would not be liable for those, would they?
No, under the duty of disclosure and the contracts, no.
So the fact that many are suspected, but not necessarily proven, to have been known to the institutions involved may in fact reduce your risk, is that right?
It may do, yes.
Thank you.
Thank you, Ron.
Well, the reality is that unless you can establish that fact, there's little chance of succeeding in a common law claim under the existing liability rules in any event.
Yes, it's complex, yes.
But a prudent insurer would certainly look at that option for an out, wouldn't he or she?
We would most definitely be prudent.
We'll discuss that further. But thank you, Mr. Whelan, and thank you for your contributions throughout. We're most appreciative.
You're very welcome.
Now we come to the Alliance for Forgotten Australians.